Breaking news, folks, out of Buffalo, New York. Another major part of New York's new gun control law has been declared unconstitutional by Judge Sinatra in the Western District of New York, the United States District Court there. Stay tuned. I'll break it down for you when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner, and constitutional attorney, member of the United States Supreme Court Bar, and New York Times bestselling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so. We're desperately trying to get to 100,000 subscribers to improve our situation with the algorithm and spread the word. Okay, folks, great news again. Another huge decision out of Judge Sinatra in the United States District Court for the Western District of New York, based in Buffalo, New York, the western part of the state. In this decision, this 27-page decision, I'll put a link to it down below, he declared that the law, as you may recall this, that Governor Kathy Hochul and the New York State Legislature enacted, this says that you are presumptively a felon if you walk onto private property, whether that be a private business or a private home, without that owner of that private business or the owner of the home publicly expressly stating to you that you are allowed to carry your gun on the premises. And if for example, the store doesn't put a big sign up that says, you are allowed to have a gun here, then you're a felon if you walk on with even if you have a concealed carry permit, if you walk onto that private property without that notice being posted by, for example, the local business, you are a felon under New York law. Well, Judge Sinatra says, no way, no how. This is not how it works, which is exactly the correct decision. Now, I know we talk a lot about these geeky kind of detailed methodological things, but we do this for a reason, because it's extremely important that the lawyers and the other people advocating in support of our Second Amendment rights get it right in court and elsewhere, so that we are victorious against these clearly unconstitutional gun control regimes like we saw in New York. And here is a major win from Judge Sinatra. Basically, if you look at this opinion, which I'm holding right in front of me here, I just printed it out. It says that under the Supreme Court's decision of Heller, McDonald, and Bruin, the New York private property exclusion, meaning the exclusion from the Second Amendment, is unconstitutional. The regulation in this area is permissible only if the government could show a historical analog from 1791 showing that such a absurd regulation that says if they don't put a big sign up, post a big sign up that says guns are allowed, then you become a felon, even if you have a concealed carry permit and you walk onto that private property without that sign posted, you become a felon. Judge Sinatra says this is no way, no how part of the longstanding tradition of regulating firearms in the United States, and therefore it is unconstitutional. Moreover, and this is huge news, the state of New York begged Judge Sinatra for a stay, which means to pause the effect of the ruling. The state of New York begged Judge Sinatra to stay his ruling for 3 days to give them time to do an emergency appeal to the Court of Appeals, the Second Circuit Court of Appeals in New York City. And Judge Sinatra says, no way, no how. Every single minute there's an unconstitutional law on the books violating the Second Amendment. It's a no-go zone, and I will not stay that decision. Therefore, the effect of this decision goes into effect immediately. I should note that the name of this case is Christian Firearms Policy Coalition and the Second Amendment Foundation. So congratulations to Brett Christian, to the Firearms Policy Coalition, and to the Second Amendment Foundation. These are major victories on behalf of Second Amendment supporters all across America, and especially in the Western District of New York. Brett Christian was a resident of Cheektowaga, New York, right there in Buffalo, and a major win for the Second Amendment there in all of Buffalo and the Western District of New York. I should mention that the way that Judge Sinatra analyzed it was basically absolutely correct. He says that Bruin held that the Second and 14th Amendments guarantee that we have the right to carry a firearm outside the home for the purposes of self-defense. He says that the central component of the Second Amendment is private self-defense, and that this is guaranteed. He specifically says that the plain text here was implicated by this ban on allowing you to, on the ban from carrying guns on private property without that posting. And because it was implicated, the burden shifted to the government to demonstrate that there's a historical analog in 1791 to show that this kind of a law existed. He then did an analysis based in history as to whether or not this kind of law existed And he says, no, it did not. Okay, so the bottom line is we're going to break this down more in a subsequent video, but right now that's breaking news, huge news, win for the Second Amendment. By the way, I should mention that Judge Sinatra also noted that he's going to be issuing a decision very soon on the question of whether or not he will enter a preliminary injunction, which means from today until the end of his case involving the Second Amendment Foundation and the Firearms Policy Coalition. He does note that the portion of the plaintiff's motion addressing public parks and public transportation will be addressed shortly, which is very interesting. And it seems to me, if you go back to 1791, there are no restrictions on carrying guns in public parks. That's just absurd to think that that could be a government-mandated gun-free zone or sensitive place, a public park that could be literally thousands of acres is somehow a sensitive place. That's just stupid, right? I think that's going to get struck down by Judge Sinatra, and also public transportation, which although I don't think there's subways in Buffalo, New York, there certainly are buses. And again, to the extent that Judge Sinatra declares, and I think he's going to, that public transportation cannot be a sensitive place because in 1791 there were no restrictions on where you brought a gun in terms of, transportation, the horses, public transportation, anything of the like. I think he's going to strike that down and declare that unconstitutional next. But right now, the only thing he did in today's order is that the restriction on carrying guns on private property where the private property owners had not posted it, saying that you're allowed to bring your gun in, he declared that as unconstitutional under the Second Amendment. Another major win. Again, we talk about the geeky stuff, but these geeky things that we talk about, these methodological things to make sure the anti-gunners don't skew the way the law should apply and the meaning of the Second Amendment, they're extremely important because I think a lot of people understand that what we talk about here and they follow through on it and they make these arguments in court, they make these arguments in the public policy space, and they win for the Second Amendment. And I think that's wonderful news that people are starting to apply the Second Amendment the proper way, including federal judges, because by doing so it allows us to vindicate our rights against crazy gun control regimes like we see in places like New York, and I think down the road very soon in places like California and New Jersey. Okay, hope you learned something. Please subscribe. We're trying to get to 100,000 subscribers as fast as we can, and we'll see you soon here at the Four Boxes Diner.
Orders up. Table 2A.